to silent. I now welcome representatives from the Australian Council of Trade Unions who are appearing in person and the Victorian Trades Hall Council who are appearing by teleconference. I understand that information on parliamentary privilege and the protection of witnesses and evidence has been provided to you. For the Hansard record, will you please state your full names and capacities in which you appear today? And I'll start with those in the room.
Good morning, Senator. Tom Roberts. I'm the Director of Legal Research and Policy at the ACTU.
Senator, it's Michelle O'Neill and I'm the President of the ACTU.
Cherie Clark, witness AIN with the QNMU.
Mark Rossetto, witness for the AMWU.
And the Trades Hall Council, please.
I'm Julian Gibson for the Hospo Voice, or United Workers Union.
I'm Josephine Foster and I'm here with the Young Workers Centre.
For the two witnesses appearing via teleconference, just to assist with Hansard, if you could state your name each time you speak, please, that would assist Hansard. Oh, they're on video conference, but maybe if you state your names too, that'll be just help Hansard. I would now invite a short opening statement, and at the conclusion of remarks, I'll invite members of the committee to ask questions. To assist the committee, I just prefer a short opening statement from one from the ACTU and one from the Trades Hall Council, please, so we can get straight into questioning.
Senator, we have kept our opening statements very short, but the workers who've come today have a very short opening statement to make, and they've prepared that in advance. So I'd appreciate if
they can table it then, if that's possible. If
I don't think it is possible to table it. So I'll be very, very quick, Senator, and let's see if we can do it rapidly, if that's okay.
Well, you were asked for opening statements to be kept to 2 minutes.
Yes.
So there'll be one 2-minute opening statement from the ACTU and one 2-minute opening statement from the Trades Hall Council.
Well, Senator, I wasn't aware you were going to limit it to one, and we have kept it to below 2 minutes.
Well, I think you were advised that the opening statement would be asked to be kept to 2 minutes.
That's right.
The purpose of this hearing is for senators to put questions to witnesses.
Point of order, Chair. Initial questions, Chair, to be directed to the workers, and we often hear 2-minute answers to our questions. So if you want to hear from the ACTU, I can commence with questioning to the workers. Thank you.
Well, if that assists, that would be fine. So if we could have one 2-minute opening statement from the ACTU and one 2-minute opening statement from the Trades Hall Council, and then I will hand over to Senator Pratt, who can ask her questions.
Thank you very much, Senator. Good morning. I want to thank the Senate for its preparedness to put this bill under proper scrutiny. Appearing with me today are Cherie Clark, who's an assistant in nursing at a private aged care facility, and Mark Rossetto, a manufacturing worker who was recently made redundant. And as you heard, on behalf of the Victorian Trades Hall Council, we have Josie Foster and Julian Gibson, two hospitality workers. All Australians deserve to fully understand the impact of new legislation, and this is especially important when the impact of that legislation reaches deep into their pay packets and reduces their rights at work. Our submission provides the details of our opposition to the bill, so I'll use my opening statement to focus on major ongoing concerns, but in the context of these broader questions. Who's this bill for? What will it achieve, and why now? Many Australians are anxious and uncertain about their jobs. JobKeeper, still so desperately needed by so many small business and 1.5 million workers, is about to go. The economic recovery claimed by the government is not universally experienced and is leaving many Australians behind. And then this bill, which fundamentally shifts more power to big business and will further suppress wages. Why would the government, who promised we're all in this together, choose this path? The ACTU wants to thank crossbench senators for their advocacy on behalf of workers that has resulted in a small change, the removal of the suspension of the boot by the government. But we fear the government will use this as window dressing, while this bill remains fundamentally flawed. Bargaining rights will be stripped from workers, and the Fair Work Commission's role in scrutinising agreements for fairness reduced to a tick and flick exercise. The rights of casual workers will be reduced, with a casual definition that will increase job insecurity. Part-time workers will lose pay and certainty, with the changes predominantly hitting women. Tradies will be left with fewer rights than all other workers, and businesses will be able to continue to use the emergency JobKeeper changes in workers' duties and place of work without the payment of JobKeeper or the protections that previously applied. This bill will take workers backwards. At the very time our country needs certainty and confidence, when small businesses are needing people to spend, this bill will enshrine insecurity and suppress wages for years to come. This is not the road to recovery. This will not create one job. We urge the Senate to reject this bill in its current form, and I'm happy to take questions on any matters related to our submission. Thank you.
Thank you. And could I have an opening statement from the Victorian Trades Hall Council, please?
So I think in this case, the workers that wanted to speak to us, you're both from the Victorian Trades Hall Council, is that right?
Yes.
Yes, okay. Well, Ms Gibson, did you want to tell us about your experiences?
Yep. My name is Julian Gibson, and I really value the opportunity to be able to share with you all my experience and why I'm asking you to reject this bill. I've worked 16 years in the hospitality industry. I've worked in cafes, pubs, fine dining and clubs, from part-time to full-time to casual. I've climbed the skills ladder from kitchen hand to chef to party. The only good job that I've had was when I was 22. I worked for a small business, a local pub. It had fair wages, paid by the hour, timesheets, pay slips and penalties. Our employer looked after us and the business thrived. I wanted to stay longer, but to build a career as a chef, you have to keep on moving. I went to one of the best restaurants in town, owned by an illustrious celebrity chef. Here I was taught the industry standard, 12-hour unpaid trial shifts, timesheets frowned upon, unpaid overtime, super never paid correctly, if at all, no breaks, no penalties, and rostering that impinges on workplace safety. Whenever I was asked for my entitlements, the typical response was, everyone is replaceable. Do you want this job or not? The last straw for me was when I was sexually harassed. I left my dream job. It turned into a nightmare. For years, every hospitality job was the same. After speaking with former colleagues, industry friends and union mates, we concluded it would seem that hospitality was never going to change. So I applied for university. I went from full-time to casual whilst undertaking a bachelor's. Getting sick, however, is a luxury a casual can't afford. So when I broke my hand, I wasn't entitled to sick leave, even though I'd been at the venue for 6 years. Centrelink took 6 months to pay me the benefit. If I didn't have the support network, there would be no way I would be able to cover my rent and bills during this time. This is what you have to choose between as a chef. Either you forfeit your self-respect and work for below the award, or forfeit your rights and entitlements and safety nets. After a decade of experiencing wage theft, it took my fellow workmates and I coming together to fight back. I got over back $15,000 for only 2 years of work out of my entire career. That money has been life-changing. It might not seem like much to you, but a safety net meant I could plan my future and make healthier choices for myself, something that chefs rarely have the opportunity to do. When Victoria introduced legislation criminalising wage theft, I cried. Finally, workers were going to have something solid and strong that couldn't be manipulated or be met with willful ignorance and poor excuses. Finally, hope for my friends and my colleagues. But now along comes this bill and I'm sick to my stomach. This legislation is a kick in the guts to workers like me who have already been brought to our hands and knees well before the pandemic arrived. We are tired and battle-weary from decades of fighting for our basic rights and entitlements. We've suffered gaslighting, wage stagnation and exploitation, and now you want to put forward a bill that further entrenches these abuses? On behalf of my fellow hospitality workers, how dare you? My experiences are not unique. There are so many businesses in the hospitality industry who undermine good businesses and who treat their staff as expendable and disposable. All this legislation does is make it easier for those businesses to continue on and increase their power over workers. All this legislation will do is ensure workers like me will continue to be exploited, for wage thieves to get away with it, and for our economy to take even longer to recover. Thank you.
Thank you, Chair. I can commence with questioning
Well, that
in the
was a
form of
question.
hearing the others. Oh, no.
No, that was a question, so Labor, you've got the call.
Thank you
have the
very
call.
much. And I have to say, That's very consistent with the experiences of my partner, who's also has had a long career as a chef. Can I ask your colleague, I think that was that you, Juliet Gibson, or was that Ms Foster speaking just now?
Hi.
Yes, please go
I
ahead.
was Julian.
Thank you, Ms Gibson. Ms Foster, would you like to speak now?
Well, good morning, committee. My name is Josephine Foster. I really appreciate the opportunity to be here today. I have almost a decade experience working in the hyper-casualised hospitality industry, and up until my last job, it was just expected that I would be ripped off. The stories that I've heard from other friends are similarly bad or even worse. Recently, a friend told me of how she was fired for warning her boss that she'd been directed to isolate for 14 days. She'd worked there for 5 years. She'd worked incredibly hard, was a favourite of most people who came in. She was fired for following the rules that have kept us safe. Are these the small businesses giving advice on how to grow jobs? My final job in hospitality was amazing. I was paid properly and treated so well, I didn't want to leave. This business is thriving. And it's because of how they treat people. No one is disposable. It's actually bad for small businesses to have lower wages, and their staff and attitude of being able to replace people at a drop of a hat actually hurts us all. It's a race to the bottom. Lower wages means people don't spend money, which means these same small businesses suffer even further. And it's because of my great love for the business that I worked for and my experiences over the years that knows that I'm actually speaking with expertise. I'm speaking from experience. And if you have a law that actually treats workers badly, we all suffer from it, because with COVID, it means that people come into work sick or they're pressured by their bad bosses to work when they shouldn't. So I suggest that when laws are changed in industrial relations, the businesses that are actually treating their workers well to start with are the ones who are consulted, because they would tell you a more complete story. We actually need positive reform that helps the businesses doing the right thing. And I'm here on behalf of so many young workers who haven't been able to share their stories. Their collective wealth they would have had stolen from them would have maybe bought them a few more seats at this table. I'm also here on behalf of those who know that small businesses run because of their workers being treated well. And I know that these businesses have got through the crisis better because they've had more people who could be covered by JobKeeper because they didn't have so many casuals who hadn't been there long enough. I'm here to protect people in other industries too, because they're becoming hyper-casualised as well. And I don't want anyone else to suffer through this through their work. I don't want the hospitality industry to become standard across the board. And I'm asking you to stand with workers and genuinely supportive bosses to reject this bill. So thank you, Senators, and thank you, Committee, for listening to me.
Thank you very much, Ms Foster. I very much appreciate that. And I know we've got some worker representatives before us this morning as well. And so very briefly, Mr Rosetto, I'd very much like to hear from your experience in the print industry.
Thanks, Louise, and good morning, Senators. My name is Mark, and I'd like to tell you about my experience as a delegate during bargaining for our recent agreement. For 27 years, I worked at one of Australia's largest magazine and catalogue printers. My role was a pre-press operator preparing digital plates to go to press. When COVID hit before JobKeeper, workers agreed to cut their hours up to 60% to help our employer through tough times. But when it came time to begin negotiations on a new agreement, my employer was not interested at all. After conciliation with the Fair Work Commission fell through, the company applied to terminate unless we agreed to reduce our redundancy entitlements back to the NES. At the same time, the company said 300 jobs would go. This was like bargaining with a gun held to your head. They said they could not afford to pay the redundancies at the EBA rate without going broke. We agreed to a new EBA that halved our redundancy, knowing it would cost us thousands of dollars so that our co-workers could keep their jobs. We were totally blindsided by the company after taking a pay cut to help. If it wasn't for our union negotiating, we would have lost everything. My fear is that if this bill is passed, big business will have even more power to reduce pay and conditions for working class people. The ink was not even dry on the agreement when the company applied to the courts to split up their business, leaving redundant workers in an insolvent company, with our entitlements now to be paid by FEGs, including myself. To this day, workers are still waiting for their FEG payment without any finances over Christmas and the New Year period, while this business rolls on, having $40 million injected into its veins by its investors. Clearly, this company could have paid the full entitlements to its long-serving employees, but chose not to. If this bill goes through, I fear workers will no longer have the confidence they can be better off. Working people's lives will be affected by big business, like my company, who will be allowed to reduce workers' rights, pay and conditions, even more than they already have. Thank you.
Ms Clark?
Hi, my name's Cherie. I've worked in aged care as an assistant in nursing for more than 20 years. My current employment contract is 16 hours per fortnight. I consistently work above these hours, but I cannot rely on it. Because of most of my work is insecure, I can only plan to live on my minimum contracted hours, and a contract of 16 hours per fortnight is not enough to live on. This impacts all aspects of my lifestyle, including health. My budget does not allow me to choose healthy options, and I often miss meals. Paying my car registration or visiting a dentist is a day-to-day decision for me. It's not just monetary, but there is also social and personal impacts of these work styles. I am unable to support my elderly parents as there's no consistency to my hours and I cannot plan ahead. I was unable to complete my Bachelor of Social Work as I couldn't afford to turn down offered shifts. As a single middle-aged female, I found myself living in temporary accommodation in a caravan park, as I've been unable to secure a long-term rental lease because I don't have guaranteed income. As a low-income worker, I'm not alone here. Where I live, most people are low-income, insecure workers. I have met 7 other aged care workers in the caravan park. I am already the working poor, and this bill could disadvantage me further. I feel though I'm under constant threat of losing penalty rates and other conditions, and without these I would be unable to continue working in aged care. It is a great honour and privilege to share a person's final journey. Our older generation deserves better, to be treated with dignity and respect, but so do the people working in aged care. We need laws that properly value aged care work and provides aged care workers with secure jobs and fair pay. This will already make a broken system worse. I'd just like to request, I've given a full statement on respect for time. I've done a written out one for you guys to consider.
That's very
I'm
much.
sure the committee would be happy to, if you table that.
Before I hand over to my colleague in the little bit of time we'll have left in Labor's bracket, I want to ask Ms O'Neill, as President of the ACTU, these workers have all had negative experiences in the existing system, so I want to ask you how this legislation specifically makes their situation worse.
Thank you very much, Senator. As you've heard from the witnesses this morning, we already have a problem in Australia with insecure work. What we're concerned about these changes, that it'll actually entrench both insecurity and also suppression of wages. And it does that in a number of ways. Firstly, in relation to bargaining, it doesn't, even with the removal of the suspension of the boot from the bill, the remaining bargaining provisions are still going to impact on driving down wages in our understanding. And that's because it removes really important protections that allow workers to fully understand what they're voting on, to be able to be represented in negotiations, and to ensure that the Fair Work Commission is able to thoroughly examine whether the agreement is consistent with the national employment standards.
Okay, so Mr Rosetto's experience in the company that he works for would be quite telling, even though in the existing system they were being pushed down through the cancellation of the award, they could have been precluded and kind of held back from participating at all in that
really
kind of
critical
dynamic.
protections in bargaining is that workers know they're bargaining. This bill delays even the notification of employees that bargaining's commenced and that they've got a right to be represented by 4 weeks. In some cases, the bargaining would be over by that time. It also removes detailed requirements in the Act for a good reason about ensuring that people really understand, and that includes things like providing information in languages other than English. It also changes the provisions that are there for good reason, to ensure that people know when the vote's going to happen, that all workers affected are able to vote, and really importantly, that scrutiny both by the Fair Work Commission, but it also removes unions' rights to appear. So if there was a substandard agreement that had been negotiated without union involvement, we will no longer have the right to appear in front of the Fair Work Commission and outline why the agreement is going to be a disadvantage to workers.
Goodness. Thank you very much. Could I go to the question of casuals? Because this really is at the heart of the bill, and many people say actually this is a big reason why the government's advanced the bill. So I can ask you specifically, what do you see as the main problem with the definition of casual employers in the bill, and who's going to benefit from the definition that's proposed at this point?
We're concerned that the definition that's been inserted into the bill does not reflect, in fact, decades of common law clarity about casual employment. And what it does is give primacy to what happens at the commencement of employment in terms of the offer of employment and how that offer is made, including what the job's called, but other factors as well, rather than the experience of what happens to a worker over time in employment. And what we know about casual workers, and is many times the case, is that they may believe that their job is casual. It may even start out as casual, but increasingly we're seeing in our country casual jobs become permanent jobs without the corresponding entitlements or rights being given to the worker. So this will in fact enshrine that problem, but particularly for big business, because it's going to be big businesses with those that have good lawyers that understand the detail of this Act, who will be able to use the provisions, the definition, to ensure that the workers that they employ never trigger the right to be a permanent worker. Would you like to add to that, Tom?
I'd just add to that by saying that the other beneficiaries of the casual changes will be those employers who have consciously misclassified their employees as casuals, because the definition, of course, applies retrospectively. So for those people who have been misclassified and are owed entitlements, those entitlements will be retrospectively extinguished.
It's quite extraordinary to act in this way retrospectively, isn't it?
It's certainly not the norm. As legislators, you'd know that the usual thing is to legislate prospectively.
And we've heard quite remarkable stories this morning from workers who I congratulate on their civic leadership, standing up and actually telling their stories. It's a very powerful thing, and I sincerely thank you for being brave enough to do that and to go through the journey of preparing your statements for us. We heard about good businesses, and we've heard about profoundly exploitative businesses here. So we shouldn't tar the whole business sector with one brush. Ms Gibson spoke about a great employer where she had great conditions. The reality is this bill is going to give both good small business owners and bad small business owners the right to say if you're casual or if you're not at the minute you start your job. Is that what this bill will do? Take the power away from workers to understand what's happening to them?
Well, it does. What it does is create, I suppose, a reversal of what the courts have found about casual work over a very long period of time. And what the courts have consistently found is that the test of whether a job is genuinely a casual, and there are genuinely casual jobs in this country, and we support those businesses that need them and those workers that are happy to work in them. But that is not the experience of many workers, as you've heard today. They continue to be called a casual, but the reality of their working life is they're working over long periods of time in regular ongoing work, but are not receiving the benefit of permanent employment. This definitional change will actually enshrine that, because rather than looking at the reality of your working life, it gives primacy to what happens when you're first offered the job.
So that's, thank you for making that so clear. Can I just ask one further question regarding casual conversion? Because there's been a lot of debate about this in the public. Like, what's the issue here that you think is important with regard to the intersection between casual conversion, current rights, proposed rights, and the Fair Work Commission? Can you just lay that out for us?
The concern that we have regarding the casual conversion provisions is that it's dressed up to look like an improvement, but the reality of it is that it leaves workers without the real opportunity to become permanent workers. And it does that because it allows the employer to say it is not reasonable for me to offer you permanent employment. So the bill says that you have to have been employed 12 months. We say that's a long period of time. And the last 6 months has to have been regular employment. And then the employer can say, well, I'm not going to offer you permanency because it's not reasonable in my business circumstances to do so. That's a very large loophole, and you can imagine the type of things that many employers would say as to why it's not reasonable, that can't be tested, because the only way that a worker can then say, well, I don't agree with that, of course it's reasonable, it's a permanent job, is they can't go off to the Fair Work Commission unless the employer agrees. So can you imagine that if you're an employer that is not wanting to give permanent work, you say it's not reasonable, you are not going to consent to go off to the Fair Work Commission and have someone independent challenge your decision. So the lack of a right to arbitration and independent review of that decision is a fundamental flaw along with the loophole.
So the stories that we've heard, again, to point out the differences between businesses, is this will give the power to determine what's reasonable to employers, some of whom are reasonable, but some who are completely unreasonable. And if you end up with an unreasonable one, you've got no chance of getting anybody to fix that situation. You just have to rely on that unreasonable employer, who we've sadly heard described to you this morning.
That's right, Senator. And of course, this is something that reasonable employers shouldn't be fearful of, because they'll do the right thing. So what this does is give an open door for those who are already acting in an unscrupulous way, already treating people badly in the way that we've heard so graphically described this morning. So it doesn't advantage those people who are the good businesses. In fact, it allows them to be undercut by the ones who are doing the wrong thing.
How does that work?
Well, I mean, this is not the only provision of the bill that opens this up. So if you're a reputable business person, you're treating people with respect. As you heard, even in the pandemic, huge amount of cooperation being done between workers and business to get through a time that none of us could have expected. But if you're an unscrupulous employer, the capacity to casualise your workforce and to treat people as casual even though they're permanent workers means that you maintain over the long term the right to dismiss people at whim. I mean, that's the key vulnerability of a casual worker. You've got no job security. You've got no job security. You can lose your job overnight with no reason, even if you've worked for years and years and years in the same position. Similarly, you don't know how much you're going to earn. And this is a problem with the part-time provisions in the bill as well. So if this is used in a way where workers have no certainty of what they're going to earn, in the part-time provisions, the removal of the penalties that apply for part-time workers with additional hours, and a removal of the certainty of hours beyond 16 hours, then you can see that they will drive down both job security and pay, literally cuts in pay for those workers in part-time employment who currently would receive overtime for additional hours worked.
Thank you. Thank you very much. Senator Pratt.
Thank you very much, Chair. Can I ask Ms O'Neill and Mr Rosetto, in the context of an approach to cancel an award before the Fair Work Commission, how does this legislation intersect with those threats to bargaining? We had some, we touched on that as we started, but I'm keen to hear specifically about the threat of terminating an agreement in the context of negotiations under this bill.
Thanks, Senator. There's a small change which extends the period where a termination can happen by 3 months. Currently could happen at the moment of the end of the nominal expiry date of the agreement. It extends it to a 3-month period. That is by no means enough of a protection to stop what we heard described by Mark, because it still allows that very real threat that if you don't agree to reduce your rights and conditions, and as you heard, these workers believing it would save their jobs. I mean, this is such a cruel setup. Believing it would save their jobs, agreed to significant reductions in their pay and conditions and rights because that threat was hanging over them. All this bill does is delay that threat by 3 months, but it has no impact on its power.
Thank you. In terms of greenfields agreements, can I ask the ACTU, in terms of major projects, if workers are locked into 8-year agreements and at the outset they, the types of workers that are able to participate in an initial agreement under this legislation. So, problems arising on major projects if workers are locked into 8-year agreements. My understanding is that the legislation, you can start a new agreement with only a small proportion of the workers that might ultimately work as part of that project initially participating in it, and that it will be locked in for some years that doesn't fit the industrial context or the skills of the workers that might participate on that site.
Yeah, thank you, Senator. In fact, greenfield agreements can be struck before any employee starts work. They can be struck by a union and an employer in these sites, but they also can be arbitrated by the Fair Work Commission if no agreement is reached by the union. So, in fact, they're the only type of agreements in the country where they can be struck just by an employer by a decision of the Fair Work Commission. The reality of what happens to workers in many of these projects and sites is that the issues that arise to do with rosters, you think of the circumstances in particular of fly-in, fly-out workers, are dramatic, and they're not always known at the commencement of the job. So over time it becomes clear that there has been, and we'll use the terrible example of the Impex project where 14 workers took their life over the life of that project. And when that has been analysed as to the risk, the mental health risks that exist for workers in these type of circumstances, it's shocking to hear how significant the rostering arrangements, the isolation from friends and family, often the accommodation and services and support that are inadequate that are provided. Now, if you remove those workers' rights for 8 years, these issues that arise over the life of the project, they've got no capacity to be able to say, well, now that we're working here, we see what these issues are and we need to have them addressed. We heard very graphically from some of the workers in Townsville about this, about examples of workers in the Barrow Island project where they expected there to be 8,000 workers and there was actually 13,000 workers with insufficient support and accommodation. So by doubling the period of time these agreements can apply, you're actually saying to these workers that are working in often isolated and dangerous conditions that you will have less rights than every other worker in the country.
So in effect...
Last question, Labor, and I'll go to Senator Faruqi.
well, if any of my colleagues want it, you're welcome to have it.
One question left for
I just
Labor.
want to just go to this question about the criminalisation of wage theft and how it's applying in the practices that occur. Is the proposed legislation effective? Is it going to, wage theft will be abolished? Is that...
Thanks, Senator.
I'll make some comments on that if I could, Senator. So I think the short answer to your question is that I think it's very unlikely that if this bill passes that these criminal sanctions will be used at all. And I say that for a couple of reasons. Firstly, many employers, of course, are corporations, and it's notoriously difficult to fix criminal responsibility on corporations. I think, in fact, the figures show that there are about 2.75 million registered corporations in the country. But if you look at the 10-year period from 2009 to 2019, there were only about 580 criminal cases brought against corporations in the whole country. So it's very important then, with that inherent difficulty of making corporations responsible, to frame an offence in a way that will work. And our view is that the way this offence is framed makes it very, very difficult for that to happen. It makes it almost impossible to prove that this sort of criminal offence has been committed.
So what would be a more appropriate way to deal with wage theft?
Well, there are a number of ways you can deal with wage theft, but including the civil sanctions that exist at the moment. But what we're saying is if the government were serious about a criminal sanction for wage theft, they wouldn't frame the offence in the way they have, where you have to prove that the person who committed the offence not only did it dishonestly by ordinary community standards, but they did it knowing that they were doing it dishonestly by those standards.
So
How on earth do you prove that sort of level? That's completely different to the Victorian legislation, which has the usual definition of dishonesty, which is just dishonest by ordinary community standards. It's inconsistent with what's in the Corporations Act. There's a bill before the Senate right at the moment that puts a new definition into the criminal code, which is consistent with the Victorian wage theft legislation. How on earth is this going to work?
Call goes to Senator Faruqi.
Thank you, Chair. Good morning, everyone. And thank you for coming to present evidence. And especially thank you to Ms. Gibson, Ms. Foster, Ms. Clark and Mr. Rosetto for sharing your stories. And I guess the sad truth is that your stories are repeated over and over again, stories of exploitation, wage theft and, poor working conditions. So I just want to assure you that for the Greens, we stand with you and we stand with all the workers in Australia. Ms. O'Neill, I might start with you. Last year, when the government presented the bill, Ms. McManus said that the proposal to weaken the boot was the most extreme idea proposed during the roundtables between union and businesses, and that despite 150 hours of consultation, the government hadn't mentioned the idea to unions before putting it in the bill. And I know that has been canned now. But are there other provisions in the bill that took you by surprise?
There are other provisions in the bill that we are very surprised to see because, in fact, they were proposals that I would characterise as being put by the more extreme end of the business lobby in Australia that during the course of those working parties did not receive broad support, not just from unions but also from some of the other employer groups. So in the intervening period between the end of those working parties and the bill hitting the Parliament, there seems to have been a shift towards adopting proposals that we think are the ones that in fact were most discredited in those discussions. Those provisions, as we've said, are ones that are really going to result in, for example, with part-time workers losing one of the important things that matters particularly for women workers. I mean, the majority of workers who work part-time in Australia are women. Many of them do so because they're trying to juggle caring responsibilities at the same time as work. And the provisions that have been put in will mean that it becomes this perverse sort of incentive that there will only be in the future 16 hours of work given, because it then allows the opportunity for the employer to say, well, if you want any extra hours, any extra work, you have to agree to be part of one of these SAHAs, the extra hour agreements. And of course, that removes all the certainty that is so often important for women who are trying to juggle these things. Not many people can live on 2 days a week, which is what 16 hours is. And so that notion that they'll have a choice to be able to say whether they're going to participate in the extra hours agreements is a false promise, because if you're only getting 16 hours guaranteed, it's not a real choice. I mean, to be able to earn what you need to look after your family and your responsibilities, you need more than that. And then, of course, what you enter into is something where you lose all certainty. So your capacity to juggle those responsibilities disappears, because 1 week you might be working 20 hours, the next you might be working 30, the next you're back to 16. All certainty about both when you work and how much you earn is disappearing.
And Ms. O'Neill, during the roundtables, I'm sure that unions raised their high priorities as well. Are any of those reflected in the bill?
The provisions that, the one area where there was consensus agreement that is reflected in the bill is the area in relation to being able to recover money, small claims. So this is when workers have experienced wage theft and they're able to have those small claims dealt with, and including in the court and in the Fair Work Commission. That was the one area of consensus.
Just one.
And it's one small part of a very significant bill. The other thing I'd say, Senator, is that if you look at it as a package, that one small area of improvement does not in any way outweigh how far backwards workers would be taken by this bill.
In Parliament, the Attorney General said that these changes will ensure workers get shifts and get paid more. What would be your response to that?
Well, that's a cruel fantasy. Because there is nothing in this bill that does that. In fact, what it enshrines is the opposite. It enshrines insecurity and a driving down of wages. And this makes no sense for the recovery. What we know from the Reserve Bank, what we know from pretty much every reputable economist in the country, is that our recovery is dependent on a recovery in wages and a recovery in certainty and confidence. And this bill is actually going to the heart of doing the opposite of that. Because if you have provisions that mean bargaining was less likely to deliver pay increases because of the nature of the changes, if you no longer have to meet the national employment standards or have that properly tested at the point when bargainings happen, if part-time workers are losing penalties, if workers in greenfield sites can't bargain for 8 years, all of these things are going to suppress wages and increase people's lack of confidence and uncertainty, resulting in a longer recession, a longer time for particularly small businesses to be able to get up back on their feet, because it's low-income workers and middle-income workers who spend their money, and they spend it often in small local businesses that are reliant on them having that confidence and money to spend.
And do you think this bill also undermines the role of unions in improving wages and conditions for workers?
It does it in a number of ways, Senator. It does it because it removes unions' rights in terms of being able to appear in the Fair Work Commission and raise issues of concerns with substandard agreements. That's important because there's many examples, and some of them are in our submissions as well as submissions from other unions, of where, in fact, it was unions appearing in front of the Fair Work Commission and raising these concerns that resulted in agreements not being passed that would have left workers worse off. If you take away our voice to do that, if you take away our capacity to turn up and say to the independent umpire, what about this, then you're actually enshrining a lack of representation and rights. And increasingly, you see agreements being struck where there's been no union involvement in the bargaining, with zero wage increases contained within them. So if unions haven't been involved in bargaining, they're more likely to be agreements with nothing in terms of a wage increase over the life of the agreement. So unlike what was said today, there's nothing guaranteed about bargaining that delivers a wage increase. What delivers a wage increase is the union involvement in bargaining and workers knowing they have a right to be represented. One of the things that it changes in bargaining is that you don't have to even tell the workers that they've got a right to be represented till 1 month in to the bargaining process. And it's that critical role of being able to be represented and have a collective voice in bargaining that delivers real improvements.
Senator Fricke, I'll go to Senator Davey.
Good morning, and thank you all for coming, and thanks to the workers for coming and sharing your story. I know that sometimes it's a bit intimidating and daunting, but we really appreciate hearing from all of you. You just mentioned the RBA governor. He's also on the record saying that we should be looking at the flexibility and complexity of our industrial relations system. And he said we should not think of part-time jobs as being bad jobs and full-time jobs as being good jobs. Would you agree with his sentiments and thoughts on those issues?
I absolutely agree with the comment about part-time jobs. Part-time jobs are very important for large numbers of workers who can't work full-time. We're not opposed to part-time jobs, we're not opposed to casual work, but it has to be done fairly and in a way that suits workers as well as their employers. And what this bill does, in the guise of flexibility, is actually strip away rights.
We've heard that a few times, and I'm sort of just trying to get to the crux of how it strips away rights. And I've also heard from past witnesses about the concerns with the conversion, casual conversion. But we've also heard from other people that the ability to convert from casual employment to permanent part-time or permanent full-time gives them certainty. And what they want is the ability to choose between whether they continue as a casual with the loadings, but the lack of certainty and the lack of entitlements, or they convert, and they appreciate the choice. but I seem to be hearing from you that you're not comfortable with the conversion factors.
No, we're absolutely comfortable with the point you raise about choice. That's correct. Some workers will say it is the fact that I wanted to continue in casual employment. So that is not our concern, Senator. Our concern is this false hope, suggesting that you've got a right to convert when many workers do, without that right actually having any substance, because of this loophole about the employer being able to say it's not reasonable for me to convert you to permanent, and the worker having no path to the Fair Work Commission to have that reviewed if the employer doesn't agree.
Thank you. Just a quick question. So if you are successful in preventing the passage of these reforms, because my understanding, and I've heard from my Labor colleagues, they don't support any part of this bill. Have you got concerns that the wage theft laws that have been brought in Queensland and Victoria against employers will be invalid in the extent that they become inconsistent with federal law? So have you got a concern that those laws, which we've heard from some witnesses, they're very happy about those wage theft laws in those states, but if they can't be applied federally because they're inconsistent?
I'm not quite sure about your question. You mean if the bill didn't pass?
Yes.
Tom, do you want to pick up on it?
Yeah, so I think it's not very clear that those laws would be inconsistent with what's already in the Fair Work Act. I think that's not the case. If it were the case, then the bill wouldn't have specific provisions in it that overrode those state laws. That's the short answer. If the government were really confident that those state laws wouldn't stand, they wouldn't bother specifically overriding them.
Thank you. Senator Solomon?
Yes, is the ACTU concerned about non-affiliated unions intervening in enterprise agreement approval applications, raising technical arguments to oppose agreements supported by affiliated unions in the vast majority of employers?
What we're concerned about in terms of this bill and its impact is the fact that it will remove the rights for unions or anyone else to appear before the Fair Work Commission and raise those concerns. That's our concern.
Do you have an objection in principle to part-time employees being able to accept extra shifts and extra hours?
Senator, that happens every day all around the country today. So all around Australia today, workers who are in part-time employment, who may be, for example, working a 20-hour-a-week part-time arrangement, enter into an agreement to change their contract of employment with their employer to become, for example, a 30-hour-a-week worker. There's nothing in the legislation today that stops that happening. It's a very common occurrence that happens in workplaces all around the country. So there's already the capacity by agreement for workers who are part-time permanent workers to change their contract of employment by consent with their employer. That's the case today.
But have affiliated unions always accepted, in enterprise agreements, the ability to be able to do that? I mean, like Woolworths and Coles agreements, my understanding is that there's a limitation for people to be able to extend beyond, say, the 38-hour minimum that they would have.
Well, it's common that in agreements, which are, I'll just remind you, are negotiated agreements, where unions and employers will say, well, what's the right balance of how part-time work and casual work and permanent work fit together in our enterprise, and how are we going to make that work so it's fair for everyone concerned? So it wouldn't be surprising, and in fact it's been changes that we've opposed for a long time that limit the number of ways you can bargain around this, but it wouldn't at all be surprising that unions and employers are able to say, well, we think the best mix that's going to deliver productivity, security and fairness is limitations on how some part-time work works, casual work works and full-time work works in a way that works for everybody. That's a common thing and should be something that people bargain around to get it right.
Quite interested in another point, but Chair, have I got...
A couple more minutes. And then I understand that Senator Faruqi has one question, and I think there's one question from Labor. So, and then we'll...
So you know that in practice, employers will choose the most cost-effective option in allocating extra shifts, don't you?
No,
That employers don't choose the most cost-effective?
not always in my experience, no.
So if part-times are entitled to overtime and a casual isn't, they will often ask the casual to work the extra shift first, won't they?
It varies workplace to workplace, Senator. I don't think that there's any evidence that suggests that there's a common approach to that.
Is 16 hours necessary, or do you think it should be available, say, to a working mother who currently works part-time for 2 5-hour shifts a week? Is it, you know, that
And if you're suggesting that, that I think some of the submissions are suggesting 16 hours is too much, I reject that as an improvement. What we know at the moment, Senator, is that there is already provisions in a large number of awards that deal with how part-time work can happen. And in fact, having an award-based approach to this, where sector and industry, you can look at what works, for example, in a clothing factory, won't necessarily work for a worker in aged care or someone who's working as a teacher. So having award provisions that deal with how part-time work applies and what's a fair minimum and what are additional hours can be done and how that operates is already different in awards across the country. But that's because they're industry specific and they deal with what works for that industry, because what works in one industry is not the same as what works in another. And that's the place. I mean, we've got a great, in fact, world-leading system here where we have industry awards that have been proven during COVID to be flexible and adaptable to the needs. That's where these sort of changes should occur.
if employers, say, covered by awards in the retail sector, do what Woolworths has done and shifted more and more employees onto part-time because of the flexibility that they got from their enterprise agreement, would that increase or decrease secure employment in your view?
Well, as I said, Senator, if it's done with agreement, if people have negotiated fair provisions about how part-time employment works and how flexibility works in relation to that, so it's not one-sided flexibility.
I'll just more or less secure
Well, it
employment?
depends on the circumstances. So if it's done fairly, if it's negotiated and people are represented, if they understand the impacts of it and they've had a say in it, if that's all been done in a transparent way, and those agreements are reached that deliver both the provisions of part-time work to workers that are fair to them, as well as provisions that work for the employer, then that's what bargaining should deliver.
What I might do, sorry, Senator O'Sullivan, is looking at the time, I need to stick to the schedule, otherwise I get stressed. Senator Walsh, you have a very quick question, and Senator Farrugia, a very quick question, and hopefully the answers are very quick so we can move on, please.
Yes, thank you, Chair. I actually want to go back to Ms Clark. You explained so well what it's like to work on 16 hours a fortnight with no guarantee of more hours. And this legislation could extend those sorts of work arrangements actually to everyone in the population by regulation. What do you think that would do to our society, to our country?
One, you're going to have a lot more working poor. You're going to have a lot more people in my situation. As an AIN, you take away my voice to stand up for the residents, because if I challenge management about conditions that are not so good in the aged care facility, they're not going to offer me another shift. Yes, it might be in my work contract that they can offer me more hours, but if I'm not a compliant worker, I'm good at what I do, but if I challenge the care and the standards for the residents, I will lose my shifts. They will give it to the worker who will just go in there and do it. If my mum is sick and I don't take a shift they offer me, they'll offer it to the next person because they'll get the next shifts offered time and time again. So it's a way to keep us removed. And yeah, as I said, in the caravan park I live in, it's a lot of hardworking people who have these work contracts. They're trying to get ahead, but we cannot get into even rental market, let alone home ownership, because we do not have that security behind me You know, if I go to a bank with a contract that says I'm only contracted to 16 hours per fortnight, they're not going to assist me. I wouldn't blame them either. It also affects small businesses because my ethics, my community, I want to be community-minded. I want to buy at the small business who's, you know, putting their kids through school. But if I buy there, I might not be able to eat next week. You know, so I've got to buy home brand or the cheaper brand or what's on special or in bulk to ensure that I've got a safety net there.
Thank you.
Thank you.
Okay, Senator Faruqi.
Thanks, Chair. So during the pandemic, we saw that company profits rose by 18.6%, but obviously zero wages growth, and thousands upon thousands of workers lost jobs. Do you think this bill is more likely to increase corporate profits than help create well-paid, secure jobs for workers?
It's one of the shocking statistics to come out of the pandemic, that growth in inequality, when there's this notion that we're all in it together, but you see the harsh reality of that in terms of particularly big business profits going up. This is not evenly spread even across the business community. It's those big businesses that are really reaping in what is record profits during the period of a pandemic, and workers' wages as a share of our national economy are at a 60-year low. And we've already had 8 years of zero wage growth, of wages being stagnant in this country. It was a problem before we hit COVID-19. COVID-19 has, of course, worsened it. But what this bill will do will be enshrine it in legislation, because it'll remove the things that workers use to be able to bargain. It'll make bargaining for fair improvements in wages and conditions harder. And, of course, it's those bargains that unions often negotiate in agreements that then flow on and that lift rights and conditions across the community. So the idea that we've seen this really uneven impact with business making record profits, workers losing hours, wages and jobs, and then that the government's response to that is this dog's breakfast of a bill that actually will enshrine pay and conditions going backwards and make jobs more insecure is unacceptable.
Thank you.
Okay, one last question, please, and then we'll move on.
Did you support the Labor Party in supporting the demerger legislation last year? And if you did, are you aware of any unions that may have plans to take advantage of that demerger legislation?
I wasn't aware that this inquiry was into another piece of legislation, Senator.
Well, I'm just quite interested in understanding the view. I mean, obviously, you don't agree with this legislation.
This is definitely not the topic of conversation today, and if we're going to go there, I want to put on the record that I think Senator Davies' characterisation of Labor's position with regard to this bill was very unsophisticated. It's an omnibus bill loaded up with a lot of terrible things we've heard this morning.
Thank you,
There
Senator
might be a
O'Neill.
couple of tiny
Senator
sweeties at
O'Neill.
the bottom, but it's a disaster of a
It's
bill.
not the adjournment in the Senate. You've got time to give speeches in the adjournment in the Senate. Ms O'Neill, have you answered the question? Or?
I have, Senator.
Okay.
Well, no, avoided the question, thinking that it's not. There is a point to this. I mean, there is a.
Chair.
Chair, there is a requirement actually. We're discussing the Omnibus Bill. This is going to affect tens of thousands of workers, tens of thousands of companies across the market, and we need to have questions regarding this bill.
Dismissal of this bill, this omnibus is put it, and I think this goes to a point about whether or not actually fair consideration is being given.
I suggest you might start an inquiry into the issue that you're raising.
What I would
and that can
ask
be discussed.
colleagues is that it is not the position of senators to critique other senators' questions. The Senator O'Sullivan has put a question to the witness, and the witness is responding in kind. I would ask that colleagues allow Senator O'Sullivan to put the question, otherwise it's going to be a very long day with senators critiquing each other. Senator O'Sullivan does have the call for this final question, and then would we please move on to the next witness.
Point of order, Chair, with respect. The question was put and the question was answered. We're past that point.
Well, I think Senator O'Sullivan was following up in terms of clarifying the question, and we could have moved on to the next witnesses now, except for the interruptions. Senator O'Sullivan.
I understood the
time
question.
of the committee. There is a point to my question, and I'd just be interested. Did you support the Labor Party's position on that demerger legislation, who they recognised that there was a importance in that. For some reason, and you've outlined some of those reasons today, Labor are not supporting any aspect of this particular bill. Just trying to get an understanding, because it seems to me that there might be, I'll put to you, that it seems to me that there might be some more ideological opposition in throwing everything out with this, rather than just considering and being fair-minded in how we approach this type of legislation to provide greater flexibility.
I reject your characterisation of that in terms of what we're saying about this bill. We've in fact put enormous time and effort over the last 12 months in terms of putting forward proposals that actually would make a difference for working Australians as well as for small businesses and towards the recovery. So what's disappointing is that the government chose to listen to the more extreme elements of the big business community in their creation of this bill, rather than the sort of proposals that we were putting forward and where there may have been some real benefit. I mean, in relation to the other bill, it does nothing to make one job more secure. It does nothing to address wage suppression. It does nothing to address issues to do with our recovery. So in terms of that bill, it was a bill that was presented to the Parliament very quickly, and one that we did not form a view of before it was voted on in this Parliament.
Okay. Line underneath the sand. Thank you very much. That concludes your evidence today.